The email landed at 9:04 on a Tuesday morning in March. By 9:11, Aldrich Communications Director of Operations had forwarded it to the General Counsel. By 9:23, the General Counsel had called Nadine Falco directly. By 9:31, Nadine was standing in the center of the Philadelphia office, holding her phone with both hands, reading 3 words that would define the next 8 months of her professional life. Cease and desist, not from a regulator, not from a competitor, from me. I was sitting in a coffee shop in Columbus, Ohio, 3 blocks from the house where I grew up, when the delivery confirmation came through on my phone. I ordered a second cup. I didn't celebrate. The letter was only the opening move, and I had learned a long time ago that nothing is finished until it's actually finished. My name is Eliot Wren. For 9 years, I served as Regulatory Compliance Lead and Script Safety Director at Aldrich Communications, a mid-sized pharmaceutical advertising agency headquartered in Philadelphia. I built the compliance infrastructure that made Aldrich's entire production operation function. Thousands of approved materials. Every production dollar protected by one man's process. 9 years of meticulous, unshowy, indispensable work. Then a woman named Nadine Falco had me removed from the company in what she described, in writing, as a strategic organizational realignment. What she had actually done was pull the load-bearing wall out of a building she didn't know she was standing in. This is Corporate Vault, where the stories that never made the company newsletter get told with the detail they deserve. If this is the first time stopping by, consider subscribing. There are 1,000 seats at this table, and the conversations get sharper with every person who pulls up a chair. I grew up in Columbus, second of 3 children. My mother cataloged books at a Westerville elementary school for 22 years. My father spent 3 decades as a city planner, reviewing zoning submissions and infrastructure proposals with the kind of careful, unshowy thoroughness that keeps Midwestern cities functional without anyone noticing the effort behind them. I was not a dramatic person. I didn't need credit. What I needed, what I was genuinely built for from an early age, was constructing systems that made complex things predictable. In high school, I color-coded my own study schedule before anyone told me that was a productive habit. At Ohio State, I double-majored in health communication and regulatory studies and graduated with a 3.91, not because I was the fastest mind in the room, but because I was the most consistent. I joined Aldrich in 2015, 9 months out of graduate school. Pharmaceutical advertising is a very specific corridor between creative ambition and federal law. Every commercial for a prescription medication, every promotional script a sales representative reads aloud in a physician's office, every patient-facing brochure, all of it has to survive a formal review process before it reaches anyone outside the building. One unsupported efficacy claim, one misrepresented risk statement, one line of copy that contradicts the FDA-approved label. Any of those things can mean a formal warning letter, a corrective campaign requirement, or a product recall. The stakes in this industry do not stay contained. When I arrived at Aldrich, they had a process. What they did not have was a system. The distinction is not semantic. A process is something that works when the right person is paying attention. A system works whether they are or not. Over 4 years, mostly on weekends and after hours so I wouldn't disrupt the existing workflow while I rebuilt it, I constructed the system. I mapped every existing approval path on craft paper pinned to a borrowed conference room wall. I interviewed every department head. I tracked every stalled submission, every last-minute rejection, every FDA inquiry that had cost a client a delayed launch. Then I rebuilt the review architecture from the structural level up, automated what could be automated, and documented every decision rule in a searchable internal database I built myself. I called it Safe Script. By 2019, nothing moved at Aldrich without Safe Script clearance. By 2021, my name appeared in client contracts as the designated compliance authority. By 2022, the agency was billing roughly $31 million annually, and the risk management framework underlying every dollar of that number was mine. I was not vocal about this. The work made its own case. In 9 years, nothing had gone wrong. And then, in March of 2023, Aldrich hired Nadine Falco as Chief Growth Officer. She came from management consulting. She had never worked in pharmaceutical advertising. She moved with the kind of confidence that, from a distance, can look almost indistinguishable from competence. Within 6 weeks of her arrival, she had identified me as the primary friction point in her growth timeline. What she did next was strategic. I will grant her that much. But strategy built on incomplete information tends to collapse at the exact moment it needs to hold. She didn't find an obstacle, she found the floor. Nadine Falco did not come at me directly. That was the smart part. A less intelligent adversary would have walked into my office in week 2, declared the compliance process bloated, and tried to override it with a memo. That would have failed visibly and left a paper trail pointing at her. Nadine was more careful than that. She understood that any frontal attack on the system would make her look reckless to the same executive team she was trying to impress. So she didn't attack the system. She attacked my proximity to the decision-makers who protected it. It started with calendar management. Aldrich held a standing Monday leadership meeting, 9 people, 90 minutes every week. I had been attending since 2018. My presence had compressed production timelines by weeks because we resolved compliance questions in the room instead of after the fact. Nadine's assistant began leaving me off the calendar invite in April. Twice I caught it and had myself re-added. The third time, the meeting location changed, and I received the update 40 minutes after it had already started. When I raised it with our CEO, a man named Walt Forsyth, he told me it was probably an administrative error and that he would look into it. Walt was 61, 3 years from retirement, and deeply committed to avoiding conflict. He had an even temperament I genuinely respected, but it made him poorly equipped for what was happening. In May, Nadine proposed restructuring the client services reporting hierarchy. Creative leads would report to her directly. Account management would route through a new VP she brought in from her previous firm. A man named Garrett Osai, sharp, fast-talking, openly uncomfortable with anything that slowed production. And regulatory compliance would be repositioned as a support function rather than a gate function. The language was deliberate. Gate functions have the authority to stop work. Support functions advise and then step aside. That distinction, encoded quietly inside a 12-page org chart, no one was going to read carefully on a Friday afternoon, was designed to strip me of the one thing that gave my role institutional weight: the authority to halt a submission that wasn't ready. I wrote a 7-page response and sent it to Walt, copied to legal, outlining exactly what the reclassification would expose the company to under FDA promotional materials guidance. I cited 5 precedent enforcement actions and attached client contractual language that in 4 cases specifically named a designated compliance authority with stop work capability. Walt forwarded my response to Nadine and asked her to factor in my concerns as the restructuring was finalized. She factored them in by adding a single sentence to Section 4 of the proposal. Regulatory compliance maintains advisory authority over all materials prior to external distribution. Advisory, not stop work, advisory, it passed. Walt signed it on a Thursday. By Friday afternoon, Garrett Osai had already emailed 2 campaign teams letting them know that compliance review timelines were now targets, not gates. I sat with that email for a long time. Here is what I understood in that moment that Nadine did not. The document trail she was building was also, inadvertently, the document trail I was going to need. Every email in which she or Garrett explicitly repositioned compliance as optional was a timestamp. Every instance in which my written objections were overridden was a record. I had spent 9 years building a system designed around documentation. I documented things by instinct. It was simply how I operated, so I kept operating, I kept writing, and I started keeping copies. June and July moved fast. Garrett was pushing production teams at a pace that in pharmaceutical advertising was reckless. 3 campaigns moved through review so quickly that my written flags, sent inside safe script as formal hold notices, were acknowledged and bypassed within hours. I escalated one to the network VP at the client level. The client paused it, asked for a revised fair balance section, and the delay cost Aldrich 11 days and a fee adjustment. Nadine blamed the delay on what she described in an internal email as an overly conservative compliance posture that prioritizes caution over client service. That email would later be submitted as evidence. But I'm getting ahead of myself. The genuinely smart move came in late July, and I did not see it coming the way I should have. Nadine hired an outside regulatory consulting firm based in Washington to conduct what she called an independent efficiency audit of Aldrich's internal compliance function. On its face, it appeared to be a standard operational review. But the firm she selected, Hargrove Compliance Partners, had a specific documented history of producing reports that recommended outsourcing internal compliance roles in favor of leaner contract-based models. She had not hired an auditor. She had hired a conclusion. The conclusion arrived in August, 38 pages long, professionally formatted, and stamped with a firm name that carried enough credibility that most of the leadership team read the executive summary and stopped there. It recommended transitioning Aldrich's compliance infrastructure to a centralized third-party model within the next 2 quarters. What the report did not mention, what Hargrove had no way of knowing because no one had told them, was that Safe Script was not Aldrich's property. Not entirely. That detail had never come up in 9 years because it had never needed to. The system worked. Everyone benefited from it. No one had thought to ask whose name was on the underlying architecture. I had thought about it. I had thought about it the entire time I was building it. The audit report landed on Walt's desk on a Thursday. By Monday, Nadine had scheduled a meeting to discuss implementation timelines. By Wednesday, I had received a calendar invite for what was described as a role transition conversation. I accepted the meeting. I went home that evening, sat at the kitchen table, and pulled out the original employment agreement I had signed in 2015. Along with a secondary document I had negotiated quietly in 2017 when I rebuilt the entire review architecture on my own time using my own tools. The word I was looking for was there. It had always been there. Proprietary. The question, the one that made my hand go still on the page for a moment, was whether it would hold. The role transition meeting was scheduled for a Wednesday at 2 in the afternoon. I arrived 4 minutes early. The conference room was on the 4th floor. Not the executive suite on 6 where serious decisions were usually made, but the space Aldrich used for vendor negotiations and client mediations. Neutral ground chosen deliberately. Nadine understood staging. She was already seated when I walked in. Garrett Osa sat to her left. To her right was Aldrich's outside employment counsel, a partner from a center city firm named Kathleen Dre, who had the particular stillness of someone who has delivered difficult news enough times that it no longer costs her anything personally. Walt Forsythe was not in the room. That absence told me more than anything that followed in the next 40 minutes. Nadine opened without preamble. She was good at that, projecting a kind of businesslike warmth that was efficient without being cold. She told me that following the Hargrove audit and a review of Aldrich's long-range growth strategy, the company had decided to move forward with a restructured compliance model. She told me my contributions over 9 years had been genuinely valued. She used the word foundational once and the phrase deeply respected twice. Then she nodded to Kathleen Dre, who slid a folder across the table. A separation agreement, 60 days of severance, health benefits through the calendar year, a standard non-disparagement clause, and a release of claims broad covering everything up to and including the date of my signature. I picked up the folder and read the first 3 pages at a pace that made Garrett quietly uncomfortable. He was the type who interpreted deliberateness as passive aggression. He wasn't entirely wrong, but the reading was also genuine. I needed to see exactly what they believed they were purchasing with those 60 days. Page 4 confirmed it. Buried in the intellectual property provisions, under a section titled Asset Acknowledgement and Transfer, was a clause requiring me to formally attest that all systems, tools, databases, and methodologies developed during my employment were the exclusive property of Aldrich Communications. I set the folder down. I asked one question. I asked whether legal had reviewed the 2017 supplemental agreement in full before drafting this language. Kathleen Dre's expression did not change, but something behind it did. The very slight adjustment of a person recalibrating. Nadine answered before Dre could. She said all relevant employment documentation had been reviewed and the agreement reflected the company's considered legal position. I thanked her for the meeting. I picked up my copy of the folder. I told them I would have a response within the allotted review period, which under Pennsylvania employment law and the terms of my original contract was 10 business days. Then I stood up, shook Kathleen Dre's hand, not Nadine's, not Garrett's, and walked out. I took the stairs, all 4 flights. The 2017 supplemental agreement existed because of a specific conversation I had with Walt Forsythe in the spring of that year. Aldrich had asked me to rebuild the entire review architecture. Not patch the existing system, replace it. The project would require 8 to 12 months of work, most of it outside standard business hours, using software tools I had personally licensed and was running on my own machine. I was not being offered additional compensation. I was being offered a title adjustment and a verbal promise of future consideration. I was 29 years old. I had been in the industry long enough to understand what verbal promises were worth when the person who made them left the company. And I had been raised by a city planner who had spent 30 years watching handshake arrangements produce consequences nobody intended. So I went to Walt and asked for a written supplemental agreement. I was happy to build the system, proud to do it for Aldrich. But I asked clearly and specifically that the agreement acknowledge the following. Certain architectural components of the system, the core decision tree logic, the flagging algorithm, the documentation framework, were being developed using my own proprietary methodology, built on tools I personally owned, on time not covered by my standard employment hours. Those specific components I wanted acknowledged as jointly developed intellectual property, with Aldrich holding an irrevocable license to use them for as long as I remained employed. Walt pushed back gently. He said it was an unusual ask. I told him I understood that and would be happy to have his legal team review the language. He agreed. The agreement took 6 weeks to finalize, 2.5 pages. It used the word proprietary 11 times. Both Walt and I signed it. A copy went into my personnel file. A copy went to Aldrich's corporate records. And a copy went into a fireproof document safe in my Columbus apartment, where I had moved it the previous January when I quietly began to wonder if things at Aldrich were shifting in ways worth preparing for. Preparation is not paranoia. My father called it reading the long horizon, the habit of noticing slow-moving changes early enough to respond thoughtfully rather than reactively. I had been reading the long horizon for months by the time I walked out of that conference room. What I had not yet confirmed was whether the specific components covered by the 2017 agreement were deeply enough embedded in SafeScript's current architecture to make the system functionally inoperable without them. That was the variable I could not control from inside the building. I had 8 business days left on my review clock when I called an intellectual property attorney named Russell Tan, based in Philadelphia, whom I had identified 6 weeks earlier and already spoken to once in a preliminary capacity. I sent him the 2017 agreement, my original employment contract, and a technical summary of SafeScript's architecture. Russell called me back the following morning. He spoke for 11 minutes. I took notes on a legal pad, and when he finished, I sat quietly looking at what I had written. He told me the agreement was solid. He told me my proprietary claim was defensible. He told me that Aldrich's attempt to include a blanket IP transfer in the separation agreement was either an oversight or a calculated attempt to close a door their own legal team may or may not have known was open. Then he told me the part that made my pen go still. The license clause, the language that tied Aldrich's right to use the proprietary components to my continued employment, was enforceable. Probably. But probably was a word Russell used with precision. He was using it now because there was a non-trivial counterargument available to Aldrich's counsel. That 9 years of organizational integration constituted an implied expansion of the original license terms, effectively converting it from a conditional license to a permanent one. A judge would decide which reading was correct. I had gone into this believing I held a clean card. What Russell told me was that the card was real, but the game it could win was not guaranteed. I set the legal pad down. I walked to the kitchen. I stood at the window for a while, thinking about what my father would have done with a set of facts that were strong but not certain. He would have filed the paperwork anyway. He would have moved forward on the best available information, accepted that some outcomes were outside his control, and built the strongest possible case from the materials he actually had. I called Russell back that afternoon. I told him to begin drafting. I did not sign Aldrich's separation agreement. The 10-day review window expired on a Friday. The following Tuesday, Aldrich sent a follow-up through Kathleen Dre's office asking for my decision. I responded in writing that I was still reviewing and would be in contact through counsel. 48 hours later, Nadine Falco made a decision I had not anticipated. One that, looking back, I believe was the first real crack in her position. She didn't wait. What Nadine did was deactivate my SafeScript credentials, not after a legal resolution, not after a signed separation. On a Wednesday morning, 11 days after the role transition meeting, while I was still technically an active employee because I had not signed the separation paperwork and my employment had not formally concluded, she instructed Garrett Osai to contact it and have my system access revoked. I found out at 7:43 in the morning when I attempted to log into the dashboard from my home machine and received an access denied notification. I sat with that for exactly 2 minutes. Then I forwarded the notification, time-stamped, to Russell Tan. He called within the hour. I could hear the particular quality in his voice of a lawyer who has just been handed something useful. He said what Aldrich had done was create an operational record of enforcement. They had treated my departure as finalized before it was legally finalized. They had, in writing, through an IT action log that was now discoverable, acknowledged that my access to SafeScript was tied to my employment status, which was precisely the framing that supported my argument about the conditional license. They had handed me a timestamp that said, "This system belongs to Eliot Wren in a way that matters." I told Russell to accelerate the cease and desist. The credential revocation created an immediate operational problem inside Aldrich's production pipeline that Nadine had not modeled for. SafeScript was not simply a review tool. It was the connective architecture of the entire compliance workflow. Client submissions routed through it. Approval chains were documented inside it. External regulatory correspondence was logged against it. The Hargrove audit had recommended transitioning to a third-party model, but that transition was projected to take 2 quarters. What Nadine had done by deactivating my credentials was remove the current operator of the system before the replacement infrastructure existed. She had pulled the pilot out of the cockpit and expected the plane to continue flying on institutional memory. For 4 days it nearly did. Garrett's team improvised. They pulled up old submission templates. They ran manual review checklists. They routed urgent questions to the junior compliance analyst, a capable young man named Forrest NG who had joined Aldrich 8 months earlier and who understood the surface of SafeScript without understanding what was underneath it. Forrest did his best. His best was not enough, not for what was coming. Aldrich's largest account was a pharmaceutical company based in New Jersey called Vanterl Therapeutics. They represented roughly 38% of Aldrich's annual billing. Vanterl had 2 active campaigns in production, a direct-to-consumer television spot for a newly approved autoimmune therapy, and a physician outreach materials package that included 3 distinct promotional items. All of it was operating on an accelerated timeline because Vanterl's launch window was tied to a competitor's market entry. I had been the designated compliance authority on the Vanterl account for 6 consecutive years. My name was in their contract, not as a courtesy, as a contractual specification. The client had negotiated that language themselves in 2020 after I caught a fair balance error in a radio script that would have triggered a mandatory corrective campaign. On the 5th day after my credentials were revoked, Forrest NG approved the physician outreach package for external distribution. He approved it because the automated flag that should have caught a misattributed clinical endpoint had been built into a proprietary layer of SafeScript that he could not access without my credentials. Because that layer ran on the core decision tree logic specifically covered by the 2017 supplemental agreement. The proprietary components had done exactly what I designed them to do. They had flagged the error and placed the file in a hold queue. What they had also done, because Forrest did not know the hold queue existed, was allow him to export what appeared to be a clean approval through the surface-level interface. 2 layers of the system, one visible to everyone, one visible only to me. The package went out on a Thursday afternoon. I was in Columbus by then, sitting across a conference table from Russell Tan, reviewing the final language of the cease and desist letter. The Vanterl regional team began distributing the physician materials on Friday morning. By Friday afternoon, Vanterl's internal medical legal team had flagged the clinical endpoint issue themselves. By end of day, their general counsel had called Aldrich's general counsel. By Saturday morning, a conference call was happening that included Vanterl's VP of Marketing, their Regulatory Affairs Director, Aldrich's leadership team, and Kathleen Dre. On a weekend, which in corporate law is a particular kind of signal. I learned about the call through a source I won't identify on Sunday evening. Vanterl was considering pulling both active campaigns pending a full compliance audit. They were also asking formally why the designated compliance authority named in their contract had been removed from the account without their notification or consent. That last question, quiet, contractual, unemotional, was the one that mattered most. Vanterl wasn't asking it out of sentiment. They were asking it because their own legal exposure was now tied to the answer. If a material had been distributed with a compliance error, while the designated compliance safeguard had been removed without client notification, the question of who bore regulatory liability became suddenly, acutely relevant. Aldrich's liability, potentially Vanterl's, 38% of Aldrich's billing on the phone on a Saturday asking where I was. I want to be precise about what I felt when I learned this. I did not feel satisfaction. The error that Forrest approved was not something I had engineered. I had no contact with Aldrich's systems from the moment my credentials were revoked. The hold queue had functioned exactly as designed. But a clinical endpoint misattribution reaching physicians' offices was a real problem. And real physicians had those materials in their hands. And that was not a thing to feel good about regardless of who bore responsibility for it. What I felt was something closer to the particular weight of having been right about something you genuinely wished you had been wrong about. I told Russell to send the cease and desist that evening rather than waiting for Monday. He pushed back on the timing. He said weekend delivery could read as aggressive and could antagonize Kathleen Dre's team before settlement conversations had a chance to begin. He told me a Monday morning delivery, calm, business hours professional, would signal that I was interested in resolution rather than escalation. This was the moment the plan wobbled. Russell was not wrong. He was experienced and careful and had navigated IP disputes longer than I had been in the workforce. His instinct for pace was usually sound, but I had information he didn't. Vanterl was already asking questions that were going to force Aldrich's hand within 48 hours regardless of what I did. Waiting until Monday meant giving Nadine's team the weekend to construct a narrative about SafeScript's functionality that I would then have to spend time and money dismantling. I had to decide in that moment whether to trust my own read of the timeline over the advice of the counsel I had hired specifically to provide judgment I might not have. I sat with it for 20 minutes. I called Russell back. I told him he was right about the tone, but I was concerned about the timeline. I asked whether we could make the delivery professional in its execution, business address, formal service, while still landing it before Monday morning gave Aldrich's team time to regroup. He said there was a process server in Philadelphia who could deliver to a registered business address Saturday evening, technically within business receipt parameters if Aldrich had a weekend duty officer, which their corporate filings suggested they did for exactly this kind of client emergency. We went with Saturday evening. The delivery confirmation came through at 6:47 p.m. I was 3 blocks from my childhood home. I ordered a second cup of coffee. I did not celebrate. The letter made one core argument. The proprietary components embedded within SafeScript remained my intellectual property under the 2017 supplemental agreement. Aldrich's license to operate those components had been conditioned on my continued employment. My employment had been constructively terminated without my agreement to the separation terms, and continued operation of SafeScript in any capacity constituted unauthorized use of proprietary intellectual property. It demanded that all SafeScript-based operations cease immediately pending resolution and gave Aldrich 72 hours to respond through counsel. Kathleen Dre responded in 51 hours, not through a letter. Through a phone call to Russell at 8 on Monday morning before the window had technically closed. That detail mattered. It told me Aldrich had spent the weekend not sleeping. Russell relayed the call that afternoon. Aldrich was not conceding the IP claim, but they were willing to open a structured conversation about resolution. The word conversation was doing a lot of work in that sentence. It meant they were not yet ready to litigate, which meant they were not certain they could win, which meant that somewhere between Friday evening and Monday morning, Kathleen Dre had read the 2017 agreement carefully and found the same thing Russell had. A real argument, a real counterargument, and the kind of legal uncertainty that makes experienced attorneys reach for the phone instead of the court filing. What it also meant was that Nadine's team had bought themselves a window, and they used it. The countermove came from a direction I had not fully anticipated, and I want to give it its proper weight because it was the cleverest thing anyone did in this entire sequence of events. Nadine found Walt Forsythe. Walt had retired from Aldrich in January, 2 months before Nadine was hired. He was living outside of Scottsdale, Arizona, spending his mornings on a golf course. He had signed the 2017 agreement. He was the only other living signatory to the document that formed the basis of my entire legal position. Nadine called him personally. What I know is what Russell told me after Kathleen Dre disclosed it in the interest of what she called good faith pre-litigation transparency. Walt Forsythe had provided a written statement, voluntarily, indicating that his intent in signing the 2017 supplemental agreement had never been to create a revocable or conditional license, and that the spirit of the arrangement, as he understood it at the time of signing, was to formalize my contribution while ensuring Aldrich's long-term operational continuity. In plain language, Walt was saying the license was always meant to be permanent, not because Walt was dishonest. He was one of the most decent people I had worked for, and I believe he wrote exactly what he genuinely remembered believing. The problem with memory is that it is not a recording. It is a reconstruction. And when someone calls you in retirement and frames a legal question around the spirit of an agreement rather than its text, reconstruction tends to drift toward the frame it's handed. What Nadine had done was find the one person whose recollection could recast the document's meaning, not through fabrication, but through the entirely human tendency to remember intention rather than language. It was her smartest move. Russell called me on a Tuesday evening to walk me through it. He was measured about it, which is how I knew it was serious. He told me Walt's statement didn't nullify the proprietary claim. The text of the agreement was still the text, but it gave Aldrich's litigation team a credible narrative to bring before a judge. Intent matters in contract interpretation. A sympathetic former CEO saying we always meant this to be permanent was not nothing. He told me we were still in a strong position. Then he paused in the way that lawyers pause when they want to make sure you have absorbed what they just said before they continue. I told him I had absorbed it. He asked me what I wanted. It was a question I had been thinking about since the Saturday evening when I ordered that second cup of coffee. Not tactically. At a level underneath tactics. In the place where you decide what a thing is actually worth to you before someone puts a number on it. I went for a walk that evening. Columbus in early spring has a particular quality. The light is still thin, but the cold has started to lose its conviction. And the streets in my old neighborhood are quiet in a way that city planners designed for without ever taking credit for it. I walked for about 40 minutes. I thought about Walt. I thought about what he had said and what he probably believed and how a man I respected had become, without knowing it, the most useful instrument in the argument being built against me. Then I thought about what I actually wanted. This is the part that gets simplified in the retelling of stories like this, where the protagonist's motivation gets flattened into a single clean drive. Revenge, money, vindication. The reality is almost never that clean. The reality involves sitting with facts that are legitimately complicated and asking yourself what outcome, when you are 70 years old, you will have been glad you chose. I didn't want my job back. I had understood that since the moment I walked down 4 flights of stairs after the role transition meeting. Aldrich, without the compliance architecture that gave it integrity, was not an organization I was interested in returning to. I didn't want to destroy the company. Roughly 230 people worked at Aldrich. Most of them had nothing to do with what Nadine had built or dismantled. A prolonged IP injunction that halted operations entirely would hurt people who had never been in that 4th-floor conference room. What I wanted was specific. I wanted the value of what I had built acknowledged formally and compensated accordingly. I wanted safe script protected, meaning if Aldrich was going to continue using it, they would use it under terms I set. And I wanted in writing a release making clear my departure had not been voluntary resignation and carried no stigma that would follow me into the next chapter of my career. 3 things, all of them defined, none of them requiring a courtroom if the other side was willing to read the room accurately. I called Russell the next morning and gave him the framework. He was quiet for a moment. Then he said what I had described was a negotiated licensing settlement with an IP valuation component and a reputational correction clause, and that it was the kind of resolution that would require Aldrich to spend real money and real pride. I told him that was accurate. He asked whether I was prepared for them to say no and take it to litigation. The honest answer was that I was prepared procedurally. The documentation was strong, and the timeline of events created a story that would read cleanly before a judge. What I was less certain about was the implied expansion argument. Walt's statement existed now. It would be entered. A judge might find it persuasive. Might. There was a real version of this story in which I went to litigation, spent 18 months and a substantial portion of my savings, and emerged with a ruling that split the difference in a way that felt like neither party won. I had to hold that version alongside the version where the documentation carried the day. I told Russell yes, I was prepared for litigation if the negotiation failed. But I wanted him to make sure Kathleen Dre understood one thing before the first formal session. That Aldrich was currently operating SafeScript without valid license to its core architecture. Every day that operation continued was a separate instance of unauthorized use. Every client submission processed through it added to the damages calculation. Time was not neutral. Every morning they chose not to settle was a morning that made the settlement more expensive than the morning before. Russell delivered that message in the precise, non-threatening language of someone who doesn't need to raise his voice because the math is already doing the work. Kathleen Dre asked for 10 days to prepare a formal response. Russell gave her 7. The negotiation opened on a Thursday morning in a conference room in Center City, Philadelphia. I was present. Nadine was not. Garrett Osai was also absent. The people in the room were lawyers, a financial advisor from Aldrich's side, Russell, me, and a court reporter whose presence I read as a signal that Kathleen Dre was taking this seriously enough to want a clean record. The opening 2 hours were procedural. Documents were reviewed. Timelines were established. The 2017 agreement was read aloud in full, which took 9 minutes and which produced a moment of particular quiet when the licensing clause was reached. Aldrich's opening position was that the proprietary components represented a minority of SafeScript's total functionality, and that their operational value did not justify the settlement framework I had proposed. They offered a lump sum that was plainly an insult, not because of the number itself, but because of what it communicated about how they had assessed my leverage. I did not react. Russell responded in writing, submitted across the table, with a revised damages calculation that incorporated every client submission process through SafeScript since my credentials were revoked. Each one logged and timestamped from the system's own audit trail, a trail I had designed to be immutable because in compliance work the record is everything. There were 412 submissions in the log. The financial advisor on Aldrich's side looked at the page for a long time. The second session happened 2 days later. The number moved. Not where I needed it, but in the direction indicating the conversation had shifted from positional to practical. By the third session, we were negotiating language rather than figures, which is where you want to be. Then, on the morning of the fourth session, Kathleen Dre arrived with something new. She slid a document across the table before Russell could open his folder. She said it had been prepared over the weekend and that she believed it changed the shape of what was possible. It was a proposal for a formal licensing agreement. Not a settlement, not a buyout. A license. Structured, tiered, renewable. Aldrich would pay an annual licensing fee for continued use of the proprietary SafeScript components. I would retain IP ownership. The fee would be indexed to the agency's annual revenue, meaning it would scale if they grew. The term was 5 years with renewal options. And embedded in Section 7, without fanfare, was a clause acknowledging that my separation from Aldrich had been an employer-initiated role elimination, not a resignation, not a performance-based action. I read the document twice. Russell read it once, in the way of someone identifying structural problems rather than absorbing content. He leaned over and said quietly that the licensing structure was reasonable. The reputational clause was exactly what I had asked for. The revenue-indexed fee was potentially more valuable over 5 years than the lump sum we had been negotiating. He also said that Section 3 contained a non-compete provision that would limit my ability to work with other pharmaceutical advertising agencies for 18 months, and that I needed to decide whether that was acceptable. 18 months. I asked for a recess. Kathleen Dre nodded without hesitation. Russell and I stepped into a narrow hallway outside the conference room. He gave me the space I needed, which meant he stood 12 feet away and let me think. I thought about it for 6 minutes. Here is what I kept returning to. I had spent 9 years inside a single agency, building something for an institution that ultimately did not value the thing it was built on. The SafeScript architecture existed because I had the skills to create it. Those skills were not housed in Aldrich's building. They traveled with me. What the licensing proposal was actually offering me, underneath the legal language, was a 5-year revenue stream indexed to someone else's growth. Meaning I would be paid progressively more for work I had already done, while Aldrich's new leadership team took the credit for results they couldn't have produced without my foundation. That was not nothing. That was, in objective financial terms, a genuinely good arrangement. But the non-compete was the cost of it, and 18 months in this industry was not a cosmetic restriction. Kathleen Dre knew that. It was the one piece of the proposal designed with real strategic intelligence, not to punish me, but to ensure that whatever I built next would not compete directly with what Aldrich was trying to rebuild. She had structured a golden cage, comfortable, profitable, and specifically dimensioned to contain me. I walked back into the conference room. I told Russell in front of the full table that I would accept the licensing structure, the revenue-indexed fee, and the reputational correction clause. I would not accept an 18-month non-compete. I would accept 6 months, covering only direct pharmaceutical advertising agency work, with a specific carve-out for independent consulting engagements that did not involve Aldrich's active client roster. Kathleen Dre looked at me for a moment. Then she wrote something on her notepad and passed it to the financial advisor. She asked for 20 minutes. She came back in 17. The non-compete was reduced to 7 months. The consulting carve-out was accepted with one modification. I could not consult for any of Aldrich's top 5 clients by billing volume during that period. I accepted. We signed preliminary terms that afternoon. Final documentation followed 12 days later. Russell shook my hand outside the building on a gray Thursday morning, told me I had handled it well, and walked toward the parking garage with the particular brisk satisfaction of a man who had enjoyed his work that week. I stood on the sidewalk for a few minutes. Philadelphia moved around me, then I drove back to Columbus. The 7 months passed with the particular quality of time that is full without being eventful. I read, I ran. I spent 3 weeks in the fall visiting my younger brother in Portland. I consulted on 2 independent projects that fell cleanly outside the carve-out restrictions. One for a health communications nonprofit building a regulatory review process from scratch. One for a mid-sized medical device company whose compliance infrastructure had the exact same structural problems Aldrich's had in 2015. Old problems, new addresses. I also spent a significant portion of those 7 months building something I had been sketching in my head for 3 years before any of this happened. Not an agency. An independent compliance consultancy with a proprietary review platform built entirely on tools I owned, documented from the first line of code, with intellectual property protections established before a single client was signed. Everything Aldrich had failed to secure, I built incorrectly from the beginning. It was called Wren Regulatory Group. It opened formally in the spring, 7 months and 4 days after I signed the licensing agreement. Within 9 months, I had 6 pharmaceutical advertising clients, 2 of them mid-sized agencies. One of them a national firm whose compliance director had called me personally after hearing my name mentioned in a conversation about what had happened at Aldrich. Word travels in specific industries. It travels along the fault lines of what people quietly know about each other. What happened at Aldrich after I left is a matter of professional record and not something I take pleasure in detailing. But it belongs to the story. Vanterl Therapeutics did not pull both campaigns. They pulled one, the physician outreach package, pending a full remediation review. The television spot was held for 6 weeks while Aldrich scrambled to reconstruct a functional compliance review process without SafeScript's proprietary components, which they were now legally required to operate only under the terms of our licensing agreement. The reconstruction took longer than projected. The Hargrove-recommended third-party compliance model was implemented at the same time, and the transition created overlapping systems with inconsistent documentation standards that, by most accounts from people still inside the building, produced exactly the kind of process without system problem I had spent years eliminating. Vanterl quietly began an agency review process in the fourth quarter. They moved their production to a different firm the following spring. They did not make a public statement about the reason. They didn't need to. Aldrich lost roughly 31% of its billing in 14 months. Not all of it Vanterl. Other clients had noticed the operational instability, and in pharmaceutical advertising, instability in compliance is not a thing clients absorb quietly. The agency did not collapse entirely. It contracted, significantly. There were layoffs in 2 rounds, the first in the spring, the second the following fall. Garrett Osei left voluntarily before the second round, which is a particular kind of departure that requires no further elaboration. Nadine Falco's exit was announced internally in the first quarter following the Vanterl loss. The language used described it as a mutual decision to pursue separate paths. She landed at a startup outside Chicago about 4 months later. A different industry, the kind of move that tells its own story without additional commentary. I harbor no particular feeling about any of this, not satisfaction, not vindication. What I feel looking back at the full arc of it is something quieter and more durable than any of those things. The system I built worked. It worked when I was running it. It continued working in its mechanical fidelity even after I was gone, flagging the error, holding the file, maintaining the record that ultimately supported everything I argued. It protected the people it was designed to protect, even in the hands of someone who didn't fully understand what it was. That is what good work actually does. It doesn't need you present to perform. There is one last thing worth saying about this. I was not surprised by what happened, not entirely. I had read the long horizon. I had seen the slow changes accumulating. I had signed the 2017 agreement not because I expected betrayal, but because I understood that circumstances shift, leadership turns over, and the value of careful work is rarely visible to people who arrived after it was already done. What I had not fully anticipated was that the resolution would take this particular shape. Not a courtroom victory, not a clean severance, but a licensing agreement that tied my name to the work I had done in a way that would pay me while I built the next version of it somewhere they couldn't reach. It was a better outcome than litigation would have produced, not because I had planned it precisely, but because when Kathleen Dre put that licensing proposal on the table, I recognized it for what it was. An acknowledgement dressed in financial language that the architecture was irreplaceable. My name is Eliot Wren. I was a regulatory compliance lead and script safety director at a pharmaceutical advertising agency in Philadelphia for 9 years. I was removed from that role in what was described as a strategic organizational realignment. I built something indispensable, watched the people who dismissed me attempt to operate without it, and spent the time they were struggling finishing the next version of it somewhere they couldn't reach. I am telling this story not because it is unusual. I am telling it because it happens quietly in agencies and corporations and institutions across this country, to careful people who build things that hold other people's work together, and who are rarely in the room when the credit is distributed or the decisions are made about what is expendable. If this is the first time at Corporate Vault, subscribe. There are 1,000 seats at this table, and every one of them belongs to someone who has sat in a room and recognized, with a particular clarifying calm, that they were the most important person in it and the least powerful one. These stories get told here with the detail they deserve. That number 1,000 is close enough to feel real. Pull up a chair. They never realize the floor is a person until they are already falling through it.